Hi everyone, and welcome to part 2 of our mini video series on criminal records, DBS checks, the Rehabilitation of Offenders Act. In part 1 of the video we focused on the Act itself and what we mean by spent and unspent convictions. We also touched on the limited remedies that are available to employees in circumstances where they are not selected for employment because of a reliance on spent convictions. In this video, we're talking about how we might want to deal with somebody who provides us with information suggesting they have a criminal record, or that may be flagged up on a DBS check. And we go into factors to consider when looking at our recruitment decisions, and also potentially terminating someone's employment if we identify that they have disclosed a conviction or it comes to light whilst they're engaged with us. So if we are undertaking vetting through a DBS check, or an employee is quite honest with us as part of the recruitment process and tells us about the offences that they have committed, particularly ones that are unspent, we have a decision to make. So it's some businesses may have a blanket policy of not employing individuals who have any criminal record at all. Others may look at the suitability of the candidate in other ways and apply other factors. We've been asked quite recently to come up with a sort of risk assessment checklist, and these are the questions that we've come up with as part of that consideration exercise. So most obviously we want to know how serious the offence is. If it's one where a significant custodial sentence was applied, for example, we may have more concerns about the employee being rehabilitated. When was the offence or offences disclosed? Did the employee volunteer them to us? Have they hidden them in some way? Have they come to light in another way? The employee's honesty and openness in this respect may be a factor to consider. Does the individual actually agree that the information that's come to light is correct? So if it's contained on the DBS record, just check it is accurate and the employee agrees with the content. We might want to we may be interested to know if any offences were work-related or committed within the context of a work setting. So one of the examples I give is if somebody's applying for a position in finance and they have a conviction relating to honesty, that may be in relation to a previous workplace. For example, if there's an allegation of theft or misappropriation of funds. How recently were the offences committed? It's likely that the longer the time that has passed between any offences, the more an employee could argue that they are rehabilitated and a changed person. What's the individual's attitude to the offences now? So as part of the interview exercise, we're trying to get into an assessment of the employee's character and, again, openness and honesty. And we're going to have to make a subjective decision about the responses that are given. Would the employee do anything differently now? So reflecting back on the offences, how would they have changed their behaviour? How have their individual circumstances changed since the conviction? So if where they live is relevant, their friends, partner, education, support network, they may all be relevant factors to a change in behaviour. Are there any mitigating circumstances in relation to the offence? So were they committed at a time of immaturity, perhaps in the individual's youth? Was this a reaction to a traumatic life event? Hopefully, again, the employee can be honest and open with us if asked. Do the matters disclosed form any pattern? So are there repeat offences? Is there repeat motivation? Is there any particular reason why, if there is more than one offence, that may have amounted to a pattern? Has the applicant demonstrated any efforts to reoffend? So have they gone on any rehabilitation courses, anger management? Have they sought help for substance abuse? That sort of thing. Is the conviction relevant to the position in question? So this is one of the biggest ones. And again, you're looking at the nature of the offence and weighing that up against the type of work they'll be doing, if they're in direct contact with the public or vulnerable people or children. And if so, again, instead of an automatic rejection, are there any safeguards that can be implemented to remove or reduce that risk if we think we need to do it? So all of those factors can be weighed up, and we may well decide, actually, this is a good candidate. They may have made some mistakes in the past, but it is worth proceeding with their recruitment. But what happens if we identify that somebody has a criminal record during employment? During the first 2 years of employment, they don't necessarily have ordinary unfair dismissal rights, so it may be low risk to dismiss. But if they have over 2 years of service, if the conviction is spent, it is not a fair reason to dismiss somebody in those circumstances, unless an exception applies. For example, an employer is typically prevented from employing somebody in a teaching capacity, even if they have a spent conviction, depending on the nature of the teaching and the nature of the conviction. But if somebody has a conviction which is unspent, that is disclosed to us during employment, and the individual has over 2 years of service, we often get the question, can we dismiss? And that's a really difficult one to answer. But typically you're going back to the factors that we discussed above, and also considering what the impact is on the employment relationship. So we said in the first video, for example, that one type of conviction that remains on a file for a year is a fine. Now, if we took a blanket view that any unspent conviction that comes into our knowledge will result in dismissal, it's likely to be unfair where a fine has been applied, depending on the nature of the work undertaken. If again, however, we have a senior finance individual who's responsible for managing money within the organisation, position of trust, works autonomously, and we identify during employment that they have an unspent conviction for a dishonesty and maybe financial dishonesty offence, we may be able to justify termination of their employment in the circumstances. Similarly, if we identify that someone has a conviction for assault or ABH or even GBH, if they're in, an office environment where they're not interacting with anybody, not going to be put in positions where they are under pressure or could be working with volatile individuals, we may take the view that there are other mitigating actions we can put into place to reduce the risk to anybody, and we may continue with their employment. If they are working in a public-facing role in volatile situations where they may come into conflict and there is evidence of anger issues which have contributed to the conviction, that could be relevant in making the determination that we want to dismiss. So lots to consider there. Not an easy decision, particularly on deciding whether to recruit or not and deciding whether we may need to terminate employment. As always, if you do need further support, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.